gentlemen, welcome to a special meeting of the Burrillville Town Council to be held Thursday, November 3rd, 2016 at 7 p.m. in the Burrillville High School auditorium, 425 East Avenue, Burrillville, falling within the town of Burrillville. Present all council members. Relative to considering and acting upon proposed contracts between the town of Burrillville and Clear River Energy LLC in connection with Invenergy Thermal Development LLC's application to construct a Clear River Energy Center power plant in Burrillville, Rhode Island, filed with the Energy Facility Siting Board on October 29, 2015. 1. Consider and take action on proposed contracts between the town of Burrillville and Clear River Energy LLC in connection with Invenergy Thermal Development LLC's application to construct the Clear River Energy Center power plant in Burrillville, Rhode Island, filed with the Energy Facility Siting Board on October 29, 2015. A. Consider and act on adopting a resolution pursuant to Rhode Island General Law, subsection 44-3, to determine an amount of taxes to be paid each year on account of real or personal property used in connection with the proposed Clear River Energy Center. B. Consider and act on adopting a resolution relative to decommissioning agreement. C. Consider and act on adopting a resolution relative to property value guarantee agreement and property value guarantee opt-out. Request the Energy Facility Siting Board to make clear River Energy LLC's compliance with the decommissioning agreement, property value guarantee agreement, and property value guarantee opt-out agreement, express conditions of any permit issued to Invenergy Thermal Development LLC by the Siting Board. Can we get a motion open?
Move to open. Second.
Motion is second. All in favor?
Aye.
Anybody got anything to say? Mr. McElroy?
Thank you, Mr. President. I prepared a memorandum of today's date that's been submitted to the Town Council, and I'd like to read it into the record. It says, this memo outlines my recommendations to the Town Council for its November 3rd, 2016 meeting to discuss and vote upon proposed agreements with Clear River Energy LLC. These agreements are: 1. The proposed tax agreement. 2. The proposed decommissioning agreement. 3. The proposed property value guarantee agreement. 4. The proposed property value guarantee opt-out agreement. And 5. A request to the EFSB to make CRE's compliance with the decommissioning agreement, the property value guarantee agreement, and the opt-out agreement an express condition of any permit the EFSB issues. The town, its attorneys, its consultants, and representatives from the council have been engaged in negotiating these agreements for over a year. The proposed agreements were negotiated and are being proposed by CRE for approval as a single unified package. In other words, if the town should vote to reject or renegotiate the terms of any of the proposed agreements, then all of the proposed agreements would no longer be on the table. Of course, it is always possible that CRE might be willing to negotiate further. As you know, as Assistant Solicitor for the town, I have taken the lead in these negotiations. I strongly believe that in order to maximize our chances of killing the proposed plan, our focus must be on putting the strongest possible case against the plan on at the EFSB hearing. My personal recommendations are: 1. The council should vote to approve the execution of the tax agreement and the decommissioning agreement. And 2, the council should vote to approve the town making a request to the EFSB that compliance with the property value guarantee agreement, the opt-out agreement, and the decommissioning agreement should be included as an express condition of any permit granted by the EFSB. My reasoning is as follows. First, on the tax agreement. It would pay $2,925,000 at a minimum in upfront fees. These payments would be available to the town prior to the commercial operation of the facility. The fees total a minimum of $2,925,000, of which $1,175,000 must be paid by January 10th, 2017. These fees are unrestricted. They can be used to fund the town's vigorous and relentless efforts to kill the plant at the EFSB and in the Supreme Court if necessary. Invenergy has already identified 19 expert witnesses who will testify at the EFSB. These include 6 engineers, 3 PhDs, and 10 other professionals in various areas. To kill the plant, we must fight fire with fire. This will require having experts who will work with the town to strongly oppose the plant. Experts and lawyers are expensive. Second reason, the agreement has a $91,960,000 minimum tax payment and a $182,324,000 maximum payment. This is a minimum average of $4.6 million per year over 20 years for just 1 unit. For 2 units, the average is $5.5 million per year minimum and $9.1 million per year maximum. By comparison, the proposed Johnston Clean Power Plant will pay only $300,000 per year. The Tiverton plant pays only $600,000 per year. The Johnston plant pays $3.6 million per year. The original Ocean State Power Plant paid $3.6 million per year. And the current Ocean State Power Extended Tax Agreement pays $2.8 million per year. The third reason, this is a guaranteed revenue stream. Entering into a 20-year long-term tax agreement would provide the town with a substantial stream of stable, predictable payments that will assist the town in budgeting and planning if the plant is permitted. Fourth, leverage. In my opinion, the town loses leverage regarding these agreements for every day the town delays approval. If Invenergy locks down a water source in the near future, we lose leverage. If Invenergy gets its air or other non-EFSB permits, we lose leverage. And if we wait until the EFSB hearings and Invenergy gets its EFSB permit, we will have almost no leverage at all. Fifth, this avoids costly litigation. By entering into this proposed tax agreement, the town avoids costly and unpredictable tax assessment litigation. The town would incur significant legal and expert witness fees, and the outcome would be uncertain. Based on my experience litigating the Ocean State Power tax assessment appeals for the town, legal and expert fees would be in the hundreds of thousands of dollars. Moreover, to the extent the owner prevails in any such appeal, the town would need to refund whatever portion of the collected taxes the court determined was in excess of the fair market value, plus annual interest at the rate of 12%. 6. This eliminates volatility in future valuations. Entering into a tax agreement with fixed tax payments that cannot be changed protects the town against volatility in the assessed value of the plant over the years. 7. CRE is committed to this project. Invenergy received an award in February 2016 from ISO New England in their forward capacity auction. Invenergy has invested millions of dollars already into permitting the project. In addition, the ISO forward capacity auction award requires Invenergy to make a firm commitment to provide the power and to provide financial assurances that it will do so, whether or not a tax agreement is in place. These assurances already required about a $4 million deposit when the FCA award was made, and they will require an additional approximately $20 million deposit of financial assurances in the next 2 years. Failure to approve a tax agreement will not, in my opinion, stop the project. Therefore, we need to do what we can to protect the town's best interests in the event the EFSB forces the plant on the town. 8. It's a guarantee of full taxability. A tax agreement assures the town that the plant will be fully taxable, and it eliminates various legal arguments that Invenergy has explicitly threatened to use to attempt to escape or reduce taxation for all or a portion of the plant if a tax agreement is not entered into. Such arguments include the manufacturing exemption, the pollution control exemption, and depreciation of personal property. All of those arguments are eliminated by entering into the proposed tax agreement. 9. It's binding on future owners. The proposed agreement is structured so that it remains fully binding even if the plant is sold or otherwise transferred to a new owner. 10. State aid. When we could not reach an agreement with Ocean State Power on an extension of their tax agreement, we've had to place them on the tax roll while we litigated the matter. This negatively impacted our state aid. If we do not enter into a tax agreement with CRE, We could again potentially suffer a negative impact on our state school aid if we put CRE on the tax roll. 11. Rhode Island municipal tax law. A few important points. Taxes are assessed on property. As the owner of the property, CRE is responsible for the taxes. A town tax lien on property is automatic, and it's superior to all other liens, including mortgages. If CRE becomes insolvent, municipal taxes have priority over all other liens, mortgages, and all other debts, with the exception of taxes or debts to the federal government or the state of Rhode Island. If CRE's taxes are ever unpaid, CRE's lenders should pay them, but if they do not, our tax collector may take the property and will sell the property for the full amount owed to the town. Next, I'd like to talk about the forms that we negotiated for the property value guarantee agreement and the opt-out agreement. A few important points. These are only suggested forms. Owners may choose to negotiate on their own if they wish. With regard to the appraisal, owners can pick a qualified appraiser of their choice to establish the base value of their home. CRE must pay for the appraisal. If an owner is dissatisfied with the initial appraisal, the owner has the right to a second appraisal, again at CRE's expense, and the base value will be determined to be the average of the two appraisals. A buyout. If the owners choose to sell their home and it does not sell within 165 days, CRE must buy the home at the appraised base value. The sale. If owners are successful in selling their home, but it sells for less than the appraised base value, they will be compensated by CRE for the difference. There is a $1,500 payment if the owners sign the property value guarantee agreement. There is a $5,000 payment if owners sign the opt-out. There is no obligation. The owners are under no obligation to enter into the property value guarantee agreement or the opt-out agreement. They are free to negotiate a different agreement with CRE or to simply do nothing. The EFSB license. The property value guarantee agreement and the opt-out agreement will be made available for owners to sign if and when EFSB grants a license to CRE. The town is not a party to these agreements, either the property value guarantee agreement or the opt-out agreement. Any agreements that are entered into would be between each homeowner and CRE directly. A license condition. The town and CRE have agreed to ask the EFSB to make compliance by CRE with the property value guarantee agreement and the opt-out conditions of any license granted by the EFSB. This means that any breach of the agreements by CRE could result in large fines and/or suspension or revocation of the CRE project license. The term property value guarantee agreement, if signed, remains in effect and available to the homeowner to use for 7 years. Now on the decommissioning agreement. The decommissioning agreement provides many protections for the town. It requires restoration of the site to its original condition unless the town agrees otherwise. CREC must pay all decommissioning costs. CREC must provide financial assurances of up to 125% of the anticipated decommissioning costs with independent financial institutions. And the decommissioning costs must be regularly reviewed and adjusted. CREC must pay the town's costs in evaluating each required decommissioning review and update. My conclusions and recommendations. In my opinion, signing the tax agreement and the decommissioning agreement will not send the wrong message to other cities in town. We have taken a very aggressive and very public position against approval of this polluting monster at the EFSB, the Public Utilities Commission, and in the press. Any approval resolution of this council should emphasize that the town remains committed to vigorously opposing the issuance of a permit by the EFSB for the proposed plan. The agreements do not diminish in any way the town's pledge to fight to kill the plan. And in fact, the agreements increase the town's ability to properly fund such a fight. These agreements will give the town the funds necessary to fight long and hard to kill the plan. If the EFSB forces the plan on the town, These agreements will assure that the town gets a known and guaranteed stream of substantial revenue that can be budgeted every year. They will avoid expensive tax litigation that could drag on for years. They will provide necessary funding for decommissioning, and they will provide some measure of protection against diminution in property values. Therefore, I recommend approval. Thank you.
Thank you, Mike. Councilors? Anybody?
Yes, at this time, I would propose a motion to adopt the resolution signing.
Allow the public to be heard.
Excuse me, excuse me.
Excuse me.
At this point, I would like to propose a motion to adopt the resolution signing
Wait
the
until after
tax
the
agreement
election.
and the decommissioning agreement on behalf of
This
the town.
is outrageous
Second.
and it's gross.
I have a motion and a second on the floor.
What happened to
All in favor? Aye. Opposed?
Are you kidding?
I have a motion to adjourn and we need a motion to make the second vote.
Motion requesting that testimony make clear compliant with the decommissioning of the property management and the decommissioning.
I have a second.
Second.
Motion and a second, all in favor?
Aye. Motion to adjourn.
Motion to adjourn.
Second.
Motion and a second, all in favor? Aye.